and set aside the decision by Advocate Mche SC, the then ANDPP, to discontinue the prosecution of the charges against Mr. Zuma. The court in the main judgment ordered that the decision of the first respondent dated the 1st April 2009 to discontinue the prosecution of the case against the third respondent in accordance with the indictment served on him on 28 December 2007 is reviewed and set aside. The ANDPP and the DSO, the first and second applicants on the other side, and Mr. Zuma, the third applicant on the other side, lodged separate applications for leave to appeal the main judgment. The applicants further seek leave against the findings of facts and or rulings and or interpretation of the law relating to rationality. The DA, the respondent, is opposing both applications for leave to appeal. The ANDPP and DSO based their applications on 6 grounds. Some of the grounds raised in their application and the grounds raised in Mr. Zuma's application overlap. Mr. Zuma, in addition, contends that there are some other compelling reasons why the appeal should be heard. Section 17.1 of the Superior Courts Act 10 of 2013 provides as follows, I quote, 1. Leave to appeal may only be given where the judge or judges concerned are of the opinion that A, Roman 1, the appeal would have a reasonable prospect of success, or Roman 2, there is some other compelling reason why the appeal should be heard, including conflicting judgments on the matter under consideration, unquote. We shall not deal with the grounds of appeal raised by the applicants ad seriatim, and we shall briefly deal with the said grounds as set out hereunder. It was submitted and argued by the applicant's counsel that the court erred in finding that Advocate Mche acted irrationally by not referring the complaint or abuse of process and the related allegations against Mr. McCarthy to court, thus rendering his decision irrational. The ANDPP and DSO in their application further stated that the effect of the finding of the court is that Advocate Mche acted ultra vires his powers. The ANDPP and the DSO submitted that the National Director of Public Prosecution and DPP has a duty to protect the institutional integrity of the institution, and it is the NDPP who is best positioned to weigh the seriousness of abuse within his own hierarchy. We record that the background facts in this case are common cause. The applicants in their applications and during argument did not challenge the court's presentation of the background facts. It is important to clarify that the respondents, the DA, in the main application, did not seek an order that the determination of the principle of abuse of process was an exercise for a court of law and not that of the NPA. Furthermore, the court did not make such a finding or such an order that in all instances the determination of the principle of abuse of process should be determined by a court of law. The applicants are notably silent about what the court said in paragraphs 70 and 71 of the main judgment. They are selective as they focused on certain portions of the judgment, thus totally disregarding the essence and the order thereof. When the main judgment is read as a whole, it is clear that on the circumstances and or facts of this case, the court is the appropriate forum to deal with the abuse of process doctrine. It is therefore not correct for the applicants to select certain portions of the judgment and deduce a wrong conclusion about the judgment. The court did not find that Advocate Mshe acted ultra vires his powers as submitted by the applicants. The ANDPP and the DSO submitted in paragraph 2.1 of their heads of argument that the finding of the court that the envisaged prosecution was not tainted is wrong. They further submitted that the court should have found that the prosecutorial process was tainted and it was not irrational for Advocate Mshe to discontinue the prosecution under the circumstances. It is clear in the main judgment that on the facts of this case, a court was an appropriate forum to deal with the issue of whether the prosecution was tainted or not. It is interesting to note that the applicants impliedly state that it is the court that should make such a finding, whilst at the same time they also argue that it is the NDPP only who can make such a finding. The main judgment clearly explains why the court is better placed to deal with the issue when a proper application is before it and all the interested parties shall have put forward their versions. It is further explained in the judgment that Advocate Mshe irrationally and hastily made a decision not having all the information before him and not waiting for the requested information. The court, in its judgment under the heading Rationality of the Decision and Abuse of the Process Doctrine, clearly dealt with the issue raised in the third, fourth, and fifth grounds in the applicant's application. It is not necessary to regurgitate what is said in the judgment, it being clear on these aspects. It is not correct, as submitted by the ANDPP and the DSO, that the court in paragraph 88 of the judgment found that once Advocate Mshe had said that the alleged conduct of Mr. McCarthy had not affected the merits of the charges against Mr. Zuma, cadit quaestio. The court in the said paragraph stated that there was no rational connection between the need to protect the integrity of the NPA and the decision to discontinue the prosecution against Mr. Zuma. The court clearly understood the argument by the applicants and the ANDPP and the DSO when the main application was heard. In paragraph 52 of the judgment, it is stated that the conduct of Mr. McCarthy, if proven, constitutes a serious breach of the law and prosecutorial policy. Importantly, Advocate Mshe made a decision without having the version of Mr. McCarthy. See paragraphs 53 and 54 of the judgment. The court further dealt with the contradictions regarding the timing of the service of the indictment as set out in paragraph 73 of the judgment. The opinion of Mr. Hofmeyr is just that and not a fact, as the applicants seek to elevate it as such. The test mentioned in the Plascon Evans Paint case was properly considered and applied in the main judgment. Mr. Hofmeyr's statement that Mr. McCarthy and Mr. Nguga had actively abused the NPA to discredit Mr. Zuma and that the motive was political cannot be regarded as a fact and binding. The other ground to support the application raised by Mr. Zuma is that the formal withdrawal of the charges on 8 April 2007 before the KwaZulu-Natal High Court was a vital factor, and that the court in its judgment should not have stated that Mr. Zuma should face the charges. In our view, the withdrawal of the charges against Mr. Zuma was not an acquittal. Such withdrawal does not nullify the decision to prosecute should Mr. Mche's decision be set aside. The said withdrawal cannot be regarded as a factor to stop Mr. Zuma to face the charges. The court had no obligation to make an order that the matter should be referred back to the NDPP for reconsideration as submitted by the applicants. In the NDPP versus Freedom Under Law case, Brand J.A. said the following, I quote, "The setting aside of a withdrawal of criminal charges and the disciplinary proceedings has the effect that the charges and the proceedings are automatically reinstated, and it is for the executive authorities to deal with them," unquote. The ground raised by the applicants that the court has breached the separation of powers is without merit. The Supreme Court of Appeal in the full case has clearly and correctly pronounced that courts should refrain from handing down orders directing the prosecution as to the execution of their functions. Such measures would encroach on the terrain of the executive branch of the state. This court has cited the SCA's decision in its main judgment and has throughout been mindful of what has been decided by the SCA. Mr. Zuma's counsel further contends that the court should have considered referring the matter back to the prosecution. That would have resulted in the breach of the separation of power doctrine. There was thus no need to make any order regarding what the NDPP should do. In our view, the issues of law concerning the grounds of review and the separation of powers doctrine have been considered and settled by the SCA in their judgments, which are referred to in the main judgment. There is thus no legal issue arising out of the main judgment which requires consideration by the SCA. The applicants further criticized the main judgment by submitting that the court did not consider the affidavit of Mr. McCarthy to the High Court that the prosecution process was of the highest integrity, whilst he, Mr. McCarthy, had been engaged in an illegal investigation in the conduct of Mr. Zuma at the time. The submission disregards the fact that when Advocate Mche made the decision to discontinue the prosecution, did not mention it. The submission was made when the main application was argued, and we did consider it. The court, in adjudicating the matter, did take into consideration what the SCA found in the Pharmaceutical Manufacturers Association of South Africa case. The court clearly stated in the main judgment that Advocate Mche's decision to terminate the process due to the alleged abuse or manipulation of the prosecution process was irrational. It was submitted on behalf of Mr. Zuma in the heads of argument in paragraph 7.5 that the decision to charge Mr. Sheikh only should be regarded as irrational. We fail to understand the relevance of this submission because Mr. Sheikh's conviction was confirmed by the highest court. Furthermore, Mr. Sheikh's issue was not mentioned by Advocate Mche when he took, when he took his decision. I'll repeat. Furthermore, Mr. Sheikh's issue was not mentioned by Advocate Mse when he took his decision, and same cannot therefore be a reason for his decision not to prosecute. There is no merit on this ground. Mr. Zuma, in paragraph 7.6 of his heads of argument, submitted as follows. I quote, "On the evidence, Mr. Mse did not act overcome, in brackets seek, emotional, nor was he pressured," unquote. Crucially, the third respondent further alleged that emotional people often take impeccable decisions. Mr. Hofmeyr clearly stated in his affidavit that Advocate Mse was angry at the time when he took the decision to discontinue the prosecution. We are of the view that the applicants have also raised irrelevant and non-meritorious factors to try and support their contention and arguments that there are other factors to be considered. The Superior Court Act has raised the bar for granting leave to appeal in the Mount Shivau Trust, Shivau spelled C-H-E-V-A-U-X, trust case. Bertelsmann J. held as follows, I quote, "It is clear that the threshold for granting leave to appeal against a judgment of a high court has been raised in the new Act. The former test, whether leave to appeal should be granted, was a reasonable prospect that another court might come to a different conclusion. See Van Heerden versus Conrad and others, 1985, Volume 2, SA 342T at 343H. The use of the word would in the new statute indicates a measure of certainty that another court will differ from the court whose judgment is sought to be appealed against," unquote. The applicants are not challenging the orders granted by the court, but they extracted and misinterpreted the following undermentioned sentences in the main judgment to formulate grounds of appeal. Namely, 1, I quote, "The court of law is the appropriate forum to deal with the abuse process doctrine and not extrajudicial process." And 2, Mr. Zuma should face the charges as outlined in the indictment, unquote. In reading the judgment holistically, it is clear that the court never created a principle that the NDPP has no power to discontinue the prosecution. Furthermore, the court did not interfere with the separation of powers principle and did not order or direct that the NDPP must continue with the prosecution. The attack by the applicants based on the above sentences is ill-founded. The said sentences should be read in the context within which they were made in the judgment and not read in isolation to create a different context. The authorities relied upon by Advocate Mse do not support an extrajudicial termination of the prosecution. Advocate Mse relied on English case law and Hong Kong case law, which did not support his decision not to prosecute. Importantly, the said authorities, the circumstances of the case, and the advice that the NPA received from their senior counsel supported that the abuse of process should be dealt with by the court. Advocate Mche's decision was carefully considered by this court. The alleged conduct of Mr. McCarthy was not brushed off by the court, hence it is stated in the main judgment that should the allegations be proved, that the conduct of Mr. McCarthy stands to be censured. When the court deals with an application for leave to appeal, leave may only be given if we are of the opinion that appeal would have reasonable prospects of success or if there are some other compelling reasons. In our view, there are no novel legal issues raised in the matter. The respondents The applicants invented novel legal grounds by misinterpreting sections of the judgment or some selective sentences in the judgment. The fact that the public has an interest in the matter is not a justification to grant leave to appeal. The matter is, of course, important for Mr. Zuma. However, if the appeal does not have reasonable prospects of success, leave to appeal should not be granted. There will, in most instances, be different interpretations. However, we have carefully considered the authorities referred to, and we are of the view that the court interpreted and applied the authorities correctly. We seriously considered whether the appeal would have reasonable prospects of success and came to the conclusion that there are no merits in the arguments raised by the applicants. We have carefully reconsidered our judgment and conclude that the appeal does not have reasonable prospects of success. We therefore make the following order. 1. The applications for leave to appeal by the first, second, and third applicants are dismissed. 2. The first, second, and third applicants are jointly and severally ordered to pay the costs of the respondent, including costs of to counsel. We hand down the judgment. That's beautiful. Court adjourns.
All right.
Yeah, I think they changed it. There was a topographic there.
I've got to read for this thing on this.
Applications for leave to appeal by the first, second, and third applicants are dismissed. 2. The first, second, and third applicants are jointly and severally.
It looks like there might be some topographical error or something, so she said